So without further discussion, I would like to introduce now Monica Palmirani. She is professor of computer science and law at Bologna University. She graduated in mathematics and holds a PhD in legal informatics and IT law. Her main interests include legislative and legal informatics, in particular XML techniques for modeling legal documents, both in structured and legal knowledge aspects, and also including normative rules. Monica, you have the floor now. Thank you very much for your participation and contribution to this seminar.
Thank you to you, Giuliano. Thank you very much for the invitation. It's a great honor to be here, and welcome to everybody. So the main topic of my talk is concerning the serialization of the knowledge in using LegalXML standards, but I want also to have a little introduction concerning the meaning of the serialization of the legal document in general. So let me recall a little bit the history that we conducted in the last decades. We started with the goal to serialize the legal document, especially legislation, with the goal to have open access in internet and to permit transparency and accessibility to the law. And so we dedicated a lot of energy in this task to serialize and open for everybody the law and the case law. But during this task performance, we discovered that we can also manage a lot of data. So we discovered a lot of knowledge included inside of the legislation, the case law, as Enrico Francesconi said before, very useful for putting evidence, for managing the reasoning on the top, and open data and linked open data combined with the semantic web became a big goal to perceive and to go ahead in this direction. But another topic was also very important to extend these technologies from the single step of a publication to all the steps of the workflow and the lawmaking system. So we assisted to the idea to create natively in digital way the legislation annotated in XML, but also with semantic web annotation. And thanks to the creation of bigger corpora annotated in the past decades, nowadays we are capable to cope with other important challenging goals, like to apply the huge amount of theory emerged in the last decades of concerning artificial intelligence, but now we can apply in concrete manner because we prepared before the corpora and the material for applying the theoretical aspect performed before. So now we are in the era where artificial intelligence and also smart contracts, machine consumable law and case law is not only an academic goal, but are both a very concrete part of some parliaments or some tribunals. There are a lot of important principles that we needed to maintain: the provenance, integrity, authenticity of a legal source, and other important principles and pillars like long-term preservation. So in the digitalization of the legislation and the case law, we need to pay attention also to the next generation in order to make reusable this material, and with a clear separation between the content approved by the parliament or by the authority, the metadata added on the top by by different actors. And finally, the presentation instructions that the media or the devices include inside of these serialization. This is extremely important. Also, the workflow and traceability of the lawmaking process is a very important goal for maintain transparent the lawmaking system. But nowadays there is an emerging new keyword, rule as a code, that has the aim to make the law and the legislation natively provided in code. So starting not by the language, not by the legal language, that is a long tradition and also based on a theoretical aspect like philosophy of law, but theory of law. But the idea is to model the law first as a code to check the consistency and the logic point of view, and then to transform in text. So this is a project that is now conducted in New Zealand, but also in Australia and in other parts, like also in the US. But this methodology is quite risky from my point of view, but not limited to my point of view. Other experts said that we needed to include in this vision the long tradition of the legal language, interpretation, argumentation. And so finally, it's a good approach to see that especially the parliament started to consider seriously the serialization of the legislation in machine consumable. But in the meantime, we need to recall all the results coming from the artificial intelligence and law community. And we have a big result to share and to include in this vision, especially in the cycle of dialogue between the human and the machine, so-called principle human in the loop. So I think the two visions are not in contrast, but could be integrated. And especially because the temptation is to jump from the idea immediately to the code and to transform the code in text, creating what is called as a black box. So I have a text and I jumping immediately in artificial intelligence output, and I am not able to justify the process, the life cycle, what happened, why, and which technology used. So this is a topic very important, call it the explicability of the artificial intelligence. And using rule as a code as is without integration with the artificial intelligence results, it is possible to have this risk. For this reason, our approach is different. We suggest to start from the text elaborated by the legal expert using legal tradition and legal language to transform step by step in a serialization, machine consumable, annotated with the semantics, as Enrico mentioned before, and then to pass to the logic representation with the simplified legal language. And then when we are so much confident of the robustness of these translations step by step, we can proceed to transform in logic formula. And finally, if you want, also in smart contract, immediately consumable and executable by the machine without intermediation of the human being. And finally, the presentation for the human. So this is our approach to track all these paths with some standards, with some principle in order to have a transparent process. This is our approach to have the document serialized in XML, combined with the different legal ontologies in the community, and also to have a serialization of the text in logic formula, combined with the ontology that can express the legal concept and the relationship between the legal concept. Obviously, all the processes should be certified by authority, like a parliament or the Gazette. And when we are quite confident of the robustness of these, we can extract knowledge serialized and linked open data, and we can combine with the rest of the knowledge available nowadays in the so-called cloud linked data, and we can combine with different other applications, geolocalization or Internet of Things, or in case also with some reasoning engine that is capable to suggest something to the judge of the public administration. And why not? The same approach is good also for the smart contract. It's quite risky to jump from the legal contract test directly to the smart contract. We can mislead a lot of concepts, and this methodology is a good also for checking the consistencies of the relationship between the legal concepts. But machine learning is one of the trends nowadays in the legal domain and artificial intelligence and law. And some remarks or open questions are already on the table. Machine learning especially works on sentences, so level, not at the document level. So we need to integrate machine learning with other vision coming from the whole document. There is time to time a missing part concerning the context of the document, like jurisdiction or temporal parameters, because machine learning is very focused on the single sentence inside the paragraph, and the relationship with the other paragraph are quite ignored by definition of machine learning. But also an important part of the debate is that machine learning depends too much to the past data, and so new law that come inside of a legal system has less importance in terms of frequency or in terms of linking or citation, and so we need to include countermeasurement to these mechanism. And also citations, machine can't distinguish too much Article 3 from 13 because only one character is the difference. So machine learning can decide that Article 3 and 13 is very similar, but we know perfectly that the two articles can say something completely different. And also the temporal aspect inside of these projects, usually of machine learning, are neglected, and we know perfectly that the dynamicity of the legal system is super important. Just a case, in case law, obviously the case law based on repealed or abrogated norms could be managed in different manner respect the case law based on enforced law. But these are open questions that need some counter-measurement, and in our opinion, the pre-markup in LegalXML in the semantic annotation can fill the gaps or can provide partially an answer to these questions. For this reason, in the last period, 10 years, we, inside of the community, we developed a lot of standards XML for annotating different level of knowledge concerning the legal document, starting from the URI, unique identifier, the document itself, metadata for enriching the information linked with the document, ontology level, and also the logic formula representation. And for this reason, inside of OASIS, that is an international standardization body, we started 2 groups, technical committees, one dedicated to XML, LegalXML, or Akoma Ntoso standard for modeling the document itself, and a second technical committee called LegalRuleML for modeling norms, so the meaning exactly of the part included in the text. Akoma Ntoso, it's an African word that means linked arts. Was founded in Africa thanks to the United Nations, but nowadays it's quite used in different countries in Europe, in US, in Brazil, and in other parts. Akoma Ntoso is capable to manage different kind of document, and it's very flexible for any customization for legal system, for any legal systems. And one characteristic is to manage the metadata for tracking the lawmaking system and the workflow during the preparation of the bill and the transformation of the bill in act. And also to track the amendments and the modification over the time in order to support the consolidation and to offer the law point in time to the citizen. And the scenarios are many where Akoma Ntoso is useful: drafting, for supporting the civil servant during the legal drafting, to help to adapt and adopt ontologies, support the translation, especially multilingualism environment, and also to track the amendments, support the cooperative work between different bodies, chamber and senate, or inside of European bodies, the council, the parliament, and the commission. And another important aspect is that Akoma Ntoso permits multiple visualization according to different devices. And now we are experimenting some artificial intelligence application and legal data analytics on the basis of big corpora that we have developed in the last 10 years. And we are now applying these techniques to the Italian legislation, but not limited to the legislation, also including case law. And these are some success story of application of Akoma Ntoso, and I'm very happy to say that the Brazil Senate was the first that believes in Akoma Ntoso and translated a partial subset of Akoma Ntoso in Portuguese and Brazilian in order to apply to the case of the Senate of Brazil. This is a snippet of Akoma Ntoso, quite easy also to read for the legal people, not the technical people. So we have a metadata in the top and the body that it is possible also to apply digital signature and multiple digital signature coming from different actors according to the power. But the second argument, the second, let me say, standard is about norms. So after the modelization of the document, we need to enter in deep of the meaning of the document, so the norms. And for this reason, we have developed, also thanks to other colleagues, one of them is Adam. Adam contributed a lot to the standard of LegalRuleML. And what is the goal of LegalRuleML? Is to model in XML standard the norms. So not simply the structure of a document, the citations, the temporal parameters that is included as well inside of LegalRuleML, but the most important part is the rules. So to transform the text in logic rules in order to permit for instance, compliance checking, or to detect anomalies inside of the document, or a bad reasoning inside of a case law. And one of the main characteristics of LegalRuleML is the association of the original text with these rules in order to have a system traceable, and from the rule I can navigate the original text of the Gazette and vice versa. And another point is that we can model multiple versions or so-called alternative of the same piece of text according to the different opinion of the scholars, of the judge, or the level of jurisdiction. So the same piece of text can have different interpretation at the European level, of Italian level, or a regional level. And all of them are equally valid depending to the jurisdiction. So the same piece of text admits or multiple rules interpretations. This is more or less how LegalRuleML looks like. There is a block of metadata very similar to Akoma Ntoso. For this reason, we have a mapping directly with Akoma Ntoso in this part. And we have the rules in the bottom and a bridge part in green that connect the metadata with the rules. So the rules in the past expert system were modeled alone, without context, without temporal information. And now we can, thanks to these mechanisms, to combine metadata and context and the rules each other's. Additionally, the LegalRuleML, because it is based on another standard called the RuleML, added specific deontic operators for facilitating the annotation of the norms. So we have operator for obligation, prohibition, permission, and so far, and also to connect each other the penalty with the obligation in order to detect immediately obligation and penalty connected. So this is quite interesting because we can make also a very complicated queries, but very useful for the legal domain. And also the feasibility. Obviously, we can have in law a main rule, but also exception of exception. And we have an easy way to define this situation inside of LegalRuleML thanks to the operators of the feasibility. This is a little example. This is a fragment of a GDPR regulation. It's a regulation, a European regulation about privacy. The Article 80 talking about the child and the permission that the child should provide to the information society services. And there is a limitation of the age, at least 16 years old. And we can model the text as is in Akoma Ntoso, first of all, with all the metadata, with the references. And this is a very important structure for applying in the second step, the logic rule. So the first step is to transform this piece of text in Akoma Ntoso. The second step is to model the logic rule. And we can also this is a LegalRuleML transformed. So we have a connection with the Akoma Ntoso thanks to some parts of the standard. So each rule is connected to the official Gazette part. And also with the ontology. So if I have a concept of personal data processing, I can connect a ontology already available, so it's not invented, but we have an ontology provided hopefully by a scholar or by the parliament. And this is ontology permits me to also detect new knowledge connected. So the child, he is connected with the parent responsibility holder, but is not written in the text. I can detect and infer thanks to the ontology. So the simple piece of text is enriched level by level in order to provide a safe analysis of the legal concept. And on the top of that, I can also manage exception. In this case, in Italy, is not 16 years old as a limit, but 14, and in other countries 13. So we can define exception of the main rule country by country, jurisdiction by jurisdiction, without to duplicate the main rule, but only to intervene on the single part that is different country by country. We have also some tools developed in the domain. This is one proposal, but there are many, and the mature are quite, the age is quite mature, the technology is quite mature to apply in the concrete scenario. So the idea at the hand is to use LegalXML for open the black box and to provide more levels of knowledge in order to track the process, the methodology for transforming the text legal binding in machine consumable, and to have also some methodology for maintaining the focus on the legal theory and the principle of the legal system. So from my point of view, we use a mixed artificial intelligence, symbolic, stochastic, and symbolic together. So my opinion, the emerging trend is to mix in a hybrid system all of them according to the goal. But on the top, I use serialization of the document in XML in order to provide the answer to the open question of the context, more information concerning citations, more information concerning the relationship between one paragraph to another, especially if they are connected by obligation and penalty, for instance. So this is my view, and I can conclude that XML in the background can help artificial intelligence to be more transparent and effective.
Thank you very much, Monica, for your brilliant and very clear, crystal clear presentation. We have a question from the audience, which is, in your opinion, how the GDPR and the laws regarding privacy would relate to these machine execution processes?
So there are many projects nowadays that have the topic the GDPR in order to transform the main rules in machine consumable. Not obviously the principal part of the first chapter of the GDPR, because are very, very high level principle, and is too much interpretation, too much shadows of interpretation. But for some chapter in the final part of the GDPR, we find obligation for the controller or some obligation for other actor involved in the data processing. And the data protection impact assessment could be a lot of benefits if the rules of the GDPR are modeled in LegalRuleML. We have inside of LegalRuleML a repository where Livio Orbaldo attempted to model all the GDPR using LegalRuleML. Is a valid, in my opinion, example, and quite exhaustive. And the idea is to reuse this material to make check compliance. So, for instance, to understand if my privacy policy is compliant with the GDPR, if all the rules that are expected are included, or to transform this piece of text in icons, because the GDPR includes also this option. And so these is our little goals, but if we can apply to all the privacy policy, is very massive in terms of volume.
Thank you very much, Monica. Just to inform the Brazilian audience, in the logarithm, and there is a project and where we try to apply Livio Robaldo's methods and of the Preco project to formalize and making to machine consumable the Brazilian data protection law.
It's a great project. So I contributed also because I cooperated with Livio Robaldo, and we have also the GDPR in Akoma Ntoso available.
Great, and we are using the Pronto ontology also that you have developed with your team.
Yes, so we use a Pronto ontology. Pronto ontology is not released open nowadays because there are some evident mistakes that I know very well, and I am fixing these. And I promise to open. We are building the portal, and before the summertime, we definitely will be ready to open Pronto. Pronto is quite a core ontology about data protection in general, starting from GDPR, but not limited to GDPR. It's based on ontology design pattern. So it's composed by modules, and each module could be customized according to a specific legal system. So it's not a very detailed ontology, is a core ontology, but the main blocks concerning temporal relationship or role agents and duty and the ontic operators are included. And I think it's a good starting point for developing something more concrete and more detailed.
Thank you very much, Monica. We now have 15 minutes of a break, a short break, and we come back with the streaming very soon. So thank you very much.